You've been arrested. Were the police supposed to read you your rights? Can your case be thrown out if they did not read you your rights? Hi, I'm Jeff Hampton with the Fulgham Law Firm. Thank you for joining us here today, and I want to welcome you to our YouTube channel because today I'm going to talk about that. What if they did not read you your rights? Some officer arrests you, you don't have your rights read. I probably get this question more than any other question that I get a couple of times a week about this issue. Can my case be thrown out? By the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, now, is it true that your case should be thrown out if the police did not read you your Miranda rights? Unfortunately, no. Almost always the answer to that question is no. Remember, what does it mean to read you your rights? People say that. What does that mean? We're talking about Miranda rights. You know what they are. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one will be appointed. You know, all that, the whole process, right? Everyone knows. You see it on TV, you see it in movies all the time. But when does a police officer have to, or an investigator have to read you your Miranda rights? Here's the key. Only if they plan on asking you questions, okay? Miranda rights only are important as it relates to confessions, anything that you might possibly say to the officer. Let me give you a common example where a police officer will choose to arrest someone and not read them their Miranda rights. Let's say a cop shows up on the outside of a house and they've got a search warrant. They come and they execute that search warrant and they find drugs in the residence, and near those drugs, they see some identifying information, maybe a wallet or some bills or something like that. And they just look at it and they say, okay, I know who this person was. They then arrest the owner of the home. And then in this situation, if the police think they have enough evidence, they may not read that person their Miranda rights at all. They'll just take them into custody, they'll book them in, and there will be no conversation whatsoever. And so you say, yeah, but wait a minute, aren't they supposed to read you your rights? Well, yeah, technically they should read you your rights, but it's not going to result in your case being dismissed or the case being thrown out unless the entire case was based upon a confession for the most part. If they're relying primarily on what you said as the basis for them pinning you to or tying you to a particular crime, then you might have a different story. Now, Miranda rights were designed, or I say designed, they were created by the United States Supreme Court in that case. You know the state Miranda versus Arizona case, where essentially it came about where in that situation someone was not read their rights and they were manipulated in a way where they didn't realize they could remain silent. And so the Supreme Court came up with the Miranda case that establishes that, look, you do not have to cooperate with a police officer asking you questions and interrogating you whenever they're investigating you. So under the Fifth Amendment, you have a right to remain silent. Now, if the officer fails to read you your rights, then you could be talking about anything that you said being thrown out. Now, in order for that to happen, we got to do a quick analysis. Number one, here's what the Supreme Court has said. Number one, in order for that to be thrown out and for a confession to be ruled inadmissible, number one, was the person in custody? In custody. So what does in custody mean? In other words, was the accused free to leave at the time? For example, if an officer walks up on someone and starts talking to them, most courts have interpreted this means that this is a consensual encounter between the two people and you are not in custody at that moment. However, if an officer detains you, puts you in handcuffs and starts asking you questions, or maybe puts you in the back of a police car and you're sitting there in the car and he gets in there and starts talking to you, that's a different story. Almost all courts have interpreted that situation. If you're in cuffs or you're in the back of a car, you are not free to leave. So if an officer fails to read you your Miranda rights in that situation, any statements that you make subsequently could be excluded for consideration and evidence, okay? So that's number one, are you in custody? Number two, was the person being interrogated? This is important as well. So in addition to having been in custody, not free to leave, you must have been interrogated by the officer. In other words, interrogation means you were being asked questions by the officer when you started talking. And the reason why I say this is a common problem we have found is what about when there's no questions being asked? And this happens all the time. You get somebody that gets nervous. They're getting arrested. And they try to start figuring out a way to talk their way out of being arrested. So they're sitting there and they're like, oh, hey, officer, what am I going to jail for? Hey, listen, all I was doing was hanging out over here. I wasn't trying to do anything crazy. Well, now the officer's not asking you any questions. You're just spewing from the mouth, and they call those spontaneous statements. Literally, you're just saying things on your own, and so as a result of that, you must be interrogated. It's not enough that you're in custody. You must also be asked questions by the officer. If you're not being asked anything and you just start talking, it's coming into evidence, okay? So keep your mouth shut. That's one good thing to realize according to the law. Finally, what if the police don't read you your rights, and if they were violated? What can your lawyer do about it? Well, there is something called a motion to suppress. So your attorney can file a motion to suppress, demand a suppression hearing, go down the elements of what the law says related to Miranda rights, and also apply those facts to the law, and pre-trial, essentially, the judge may be able to rule that confession is to be thrown out, or any statements that were made thrown out. That could provide you reasonable doubt for your case. It could also result in you being able to resolve your case in a much more favorable way, okay? Now, what's the real lesson here? Even though the police should always read you your rights, the reality of it is it doesn't change the fact you have rights. Don't worry about Miranda rights when you're going to exercise your right under the Fifth Amendment to remain silent. Take the Fifth. Don't say anything else to the officer. Don't let that police officer twist or misinterpret what you're saying, okay? Now listen, I hope this video has been helpful to you. I promised you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Click through down to the notes in the bottom. Send over your email. We'll be happy to send that back to you. I want to thank you for joining us here today. Subscribe to our YouTube channel. We'll send you more great content just like this. Thanks.